Thank all of you for being here today to talk about this important and emerging issue. On today's webinar is called E-Registry bills and their implications for public health. I want to begin by reminding everybody that these webinars are open and available to the public, and the recording will be made publicly available. This webinar in particular has garnered a lot of interest, which is great, and folks from all sides of this issue are participating, including potentially folks who represent industry interests. And so we're going to work extra hard to ensure that we're providing accurate information and to facilitate a respectful conversation. As Stephanie mentioned, you can pose questions as we go through this presentation through the Q&A icon. If you do have state-specific questions, feel free to ask those, but we'll likely request that you reach out to us after the fact to ask your state-specific questions, and either somebody from PHLC or one of our great panelists will be able to help you out. My partner and colleague, Marissa Katz, is going to be monitoring the Q&A as we go through, and if she's unable to answer any of your questions directly through the chat, we'll be saving them for a Q&A portion at the end of our panel conversation. Without further ado, I want to introduce today's presenters. I'm very honored to have them join us today. I really appreciate them donating their time and expertise to discuss these important issues. We're going to begin by introducing Megan Boelter. She is with the Western Regional Director with Preventing Tobacco Addiction Foundation. She is an attorney with 18 years experience as a tobacco control policy analyst and educator, both in the United States and abroad. She has a focus on the tobacco retail environment, supporting evidence-based tobacco control measures that limit youth access to tobacco and that reduce tobacco-related health disparities in vulnerable communities. Thank you for being here, Megan. Next is Ashley Lyerly. She's the Senior Director of Advocacy for the American Lung Association. She leads the Lung Association's policy and advocacy activities in the Southeast on tobacco control, access to care, and healthy air issues. She has over 10 years experience managing numerous policy campaigns and initiatives to improve tobacco control policies at the state and local level. Thanks for being here, Ashley. We also have Claudia Rodas, who is the director for the Southern region of the Campaign for Tobacco-Free Kids. She has over 20 years of experience in political and legislative matters. Her current work focuses on commercial tobacco control policies spanning 13 states, primarily in the southern and southwestern region of the country, where she provides strategic and tactical support to state and local campaigns and coalitions on tobacco control policy issues. Thanks, Claudia, for being here. And last but not least, we have Janine Young, who works as a regulatory inspector with the San Francisco Department of Public Health and has done for over 25 years. She served as the project lead for San Francisco's flavored tobacco implementation and enforcement rollout, and is one of the regulatory representatives for San Francisco's secondhand smoke prevention and tobacco permitting laws, which are enforced through the Environmental Health Branch, where she works on compliance and enforcement efforts with the city and community partners. Thank you, Janine. My name is Tom Pryor. I am a staff attorney here at Public Health Law Center. I'm joined by my colleague, Marissa Katz, also a staff attorney. We'll be moderating the discussion, and once again, want to thank our panelists and presenters for being here today. Now, the Public Health Law Center is located at Mitchell-Hamlin School of Law in St. Paul, Minnesota. I want to begin by acknowledging that we are in the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in the area. We appreciate their ongoing stewardship, spiritual connections, and the life ways they've developed in these homelands upon which the law school sits. PHLC offers free legal technical assistance to all communities, public health advocates, and other partners. We also publish widely on commercial tobacco control policy, and we offer trainings and webinars like this one. We do not, however, offer direct legal representation, nor do we lobby. At PHLC, we consider it our responsibility to use our legal knowledge to bring justice to public health, which includes addressing the social determinants of health as we support our partners in reducing health disparities. When all people are healthier, the communities are happier, safer, and more vibrant places. We also prize equity above equality. Equity is about giving people what they need, which includes understanding barriers, circumstances, and conditions. In an equitable society, something like your race, gender, or sexuality should not be predictive of your health or happiness. And finally, I want to mention before we jump in that when we talk about tobacco products, we're going to be discussing them in terms of industrial scale commercial tobacco production, not traditional tobacco, which is used religiously, medicinally, and ceremoniously in many different cultures and tribal nations. The agenda for today's webinar is pretty straightforward. I'll be giving a brief overview of these e-registry laws. I also want to note at the outset that we do have a blog post on this subject on the center's website, and also a map showing where these laws have been introduced across the country. The bulk of our time is going to be spent on a moderated panel discussion, and we'll make sure to leave some time for Q&A at the end. So as I mentioned, please do enter your questions in the chat, and we'll collate and ask our panelists to respond to them at the end to the extent those issues haven't been addressed already. All right, with that, let's give a brief overview of these e-registry laws. And really what we need to begin with is talking about the FDA and its pre-market tobacco product application, or PMTA, process, because all of these e-registry laws that we'll be discussing relate to or incorporate that process and how the laws operate. So in order to understand the e-registry laws, we have to understand the FDA's PMTA process. And what I want to start with is a really basic concept, which is that the FDA is tasked with authorizing tobacco products. It does not approve them. It can give approval for various food, drugs, or devices that are deemed safe and beneficial for public use, but there is no safe and beneficial use of tobacco products. So all the FDA can do is authorize them for marketing. And another message that we'll return to consistently throughout the presentation is that all new tobacco products, including e-cigarettes, need to apply and get authorization from the FDA before they can be legally marketed in the United States. Now, when a company develops a new tobacco product, they need to apply for this authorization, and they'll supply a variety of information about their product to the FDA, including scientific studies about the product's safety risks. And the FDA will review that information and make a determination based on factors like the risk and benefit to public health, the impact of the product on cessation efforts or tobacco uptake among non-users, as well as information about the manufacturing process and safety standards associated with the product's development. And when they've reached a decision, the FDA will either authorize the product for sale, which is called issuing a marketing grant order or an MGO, or they will deny the product's application, otherwise called issuing a marketing denial order or MDO. Now, thus far, the FDA has only authorized 23 e-cigarettes to be marketed within the United States. And I'll also note that all of those are either non-flavored or flavored as traditional tobacco products. Now, of course, at any point in time, there can be thousands of applications that are still pending at the FDA at the review stage and have not yet received the definitive MGO or MDO. And doing some kind of back of the envelope math, we estimate that there could be up to 400,000 products that have applications at the FDA that the FDA is reviewing or about to review, but has not yet issued any action on them. Note also that just because an application has been denied does not necessarily mean that the FDA will take enforcement action against the manufacturer if it markets those products. The applicant can file a lawsuit over that denial and secure a judicial stay, or it can request an administrative stay from the FDA directly. But the point that the FDA does make clear in multiple places is that you cannot legally market your e-cigarette without a marketing grant order or MGO. Now, that's a far cry from saying that you'll get in trouble for marketing your e-cigarette. The FDA has limited resources and can't pursue every manufacturer who is marketing an e-cigarette without authorization. So instead, it prioritizes enforcement action against products that are likely to appeal to youth, including flavored products, and products that never went through the PMTA process in the first place, as well as products that receive definitive MDOs or denials. The bottom line here is that there are potentially thousands of products or hundreds of thousands of products that have applied to the FDA for authorization and still have applications that are pending or that have stays. But there are only 23 products that have received authorization, and thus 23 products that can legally be marketed in the United States. All right, with that in mind, let's look more specifically at these e-registry bills. And I want to note at the outset that there are a lot of laws in various states that use words like registry or directory in the tobacco control space, but we're talking about a very particular sort of e-registry bill that has been proposed in states across the nation in the last couple of months. This map was put together with help from some of our panelists as well as other members in the public health community, and it shows the roughly 24 bills that have been filed this legislative session, as well as the 4 states that already have e-registry laws on the books. And I put it here just to emphasize that these laws or these bills have been sweeping the nation in what is obviously a very coordinated effort. So what are these laws? Now, the typical e-registry law that we're talking about today establishes a state-run directory of e-cigarette products that can be sold within the state and limits the products that can be included within that directory to those that have submitted PMTA applications to the FDA and have either received authorization from the FDA to sell them or have not yet received a definitive denial from the FDA. So the typical law will include language saying something to the effect of that the product's application with the FDA either remains under review or the application denial has not yet taken effect. And that language is key because a denial has not yet taken effect if it's been stayed, either a judicial stay or through an administrative stay. Other laws are more explicit on that point and will say that products can be placed on the directory if they've received a court order staying a denial. And I also want to emphasize that there are hundreds of thousands of pending applications before the FDA and no reliable data on the number of FDA denials that have received administrative or judicial stays, although that number could also easily number in the hundreds of thousands as well. So there are potentially up to maybe even 1 million products that could potentially qualify for these typical e-registry bills. Importantly, the laws also typically leave it up to the manufacturer to certify to the state agency that their product qualifies because it either has a pending application or its denial has been stayed. Now, to my knowledge, there's no reliable, efficient way of determining which denials have been stayed, nor is there a great, easily accessible way of determining which products have pending applications, really meaning that the self-certification is doing the heavy lifting of determining if these products belong on the directory to begin with. Now, the result is what you can see in the image here. This is a screenshot of Alabama's directory. They have an e-registry law that's in place. And as you can see, there's almost 1,600 products included on that directory, which is actually, when you think about it, quite a small number given the number of products that could potentially qualify for it. Now, as an alternative approach, a state could set up a directory and limit it to only those products that the FDA has authorized. And that's what Maryland's bill does, for example. And as we'll discuss a little bit later, that's effectively what the city of San Francisco does. That would limit the number of products that can be sold within that jurisdiction to only those 23 that are currently authorized, which is pictured here. And you can kind of get a sense of what the difference makes just from an enforcement standpoint by contrasting the Alabama's registry with 1,600 products on it to what is effectively San Francisco's registry containing only 23 products. All right, with all of that in mind, let's turn to the panel discussion. This is going to be a panelist-driven discussion. I'm going to recede into the background as much as possible here, but here are some topics that I'm hoping we can cover, including discussing the important distinctions between the various laws that have been proposed around the nation, talking about how these laws work in practice, what we know from those 4 states that have implemented them, what are the public health implications of these bills, and on balance, whether public health advocates should support or oppose these, or what kind of guidance we can provide folks. And so let's begin with that first this question, talking about the important distinctions between these various proposals. And what I'd like to do is begin with Janine from San Francisco. And if all the panelists can come on screen and we'll dive into this. Janine, can you run us through how San Francisco's e-registry law, to the extent you would even call it that, operates in practice so that we can kind of contrast that San Francisco model to the models that we're seeing across the nation?
Oh, great. Good morning, everyone. Yes, so San Francisco in 2019 passed San Francisco Health Code Article 19R, which said that you cannot sell or distribute any e-cigarette that has not been authorized by the FDA. So they must actually receive their authorization, their FDA premarket authorization. Originally, when the law first went into place, it was very extremely difficult, even for our team, to determine what was authorized by the FDA. I mean, we had to go on the FDA website. There were 4 different links with different information, and we spent time researching. And in 2020, it was only a couple of products. So because it was so limited, we decided to at least put on our website, on our webpage, those limited products. And then we went out in the field to basically, do compliance inspection. And what we were finding in the field, that even though the FDA authorized only in 2020 limited, like it was 2, none of our retailers knew about it. The retailers were receiving their information from their distributors, from their vendors, and what the distributors and vendors were telling everyone, that as long as there was an application into the FDA, as long as the FDA decision was pending, that they could sell those products. So we spent the majority of our time really educating. Now we are at 2024. We are still finding e-cigarettes on the shelves, flavored e-cigarettes on the shelves, even though and the FDA authorization list has only increased from the 2 in 2020 to now 23 in 2024. And that, again, is because a lot of our retailers are listening for what their distributors are saying, and they're listening and observing what is going on in other jurisdictions. So we have rules and regulation, which when we see this, we actually tell them that they have 72 hours to remove the products off the shelf. And if it's a flavored e-cigarette, that cannot be sold at all in San Francisco.
Yeah, thanks for sharing that. And it's always kind of sobering to hear that places like San Francisco in California are struggling to implement what sounds like a very simple and straightforward approach to this. So I'm wondering if somebody else, maybe Megan, would be able to share some information about other states' bills, and in particular, maybe some things that we know about how these bills are written and some of the distinctions between them that might make those sorts of enforcement things more or less difficult. Sorry to put you on the spot there, Megan.
No worries. Thank you. Yeah, so what we're finding in a majority of the states that I work in is that it is not clear which products would actually qualify. Also, the verification of the product. So even if a product was within the PMTA process, what is the documentation that proves that? And we're also finding that the legislators are being led to believe that so long there is as the PMTA application is pending, meaning you just have applied for product authorization, marketing authorization, that validates the safety or efficacy of the product under review. And again, pre-market tobacco application, that's before marketing. And so we're having to do a lot of backup education with legislators. And just a few points in terms of the variety. Some of the registries provide for a listing of the manufacturers, as opposed that the manufacturers pay a fee to be included as an authorized manufacturer. In other cases, it has to do with the product. Some require a fee per manufacturer with an annual fee, or a product application fee, and then an annual registration of that same product every year. There are only 4 states that have actually adopted legislation. 3 have implemented. The 3 that have implemented are Louisiana, Alabama, and Oklahoma. 2 of the 3 are now providing cleanup bills because there wasn't adequate funding or resources for the administrative and enforcement burden. And then Louisiana's is currently enjoined due to a lawsuit against the state and the enforcement agency, claiming that there's a problem in terms of the qualifications for which products would actually be allowed for sale on the market. So that's a brief overview. I know my other panelists know, and if we can go further into the states, but just an idea of the fees go from 0 with no manufacturer responsibility to now Oklahoma is having to address the lack of funding with a $5,000 fee per manufacturer, not per product, to help fund just the administration. Overwhelming number of products. For Oklahoma, it was upwards of 10,000 products. And eventually we can show just an example of what one of those registries looks like and how hard that is really to maintain, to describe an individual product, and then to verify that with any sort of FDA listing, considering that they all have different names, different different types of nicotine, and different volumes. So the idea is that it's just a messy administrative burden at the moment, and the states that have adopted are really trying to recover and sort out what is consistent among the paperwork versus product versus manufacturer.
Yeah, I appreciate that. And the funding piece, I'm sure, is huge, and that's kind of where the rubber meets the road with a lot of laws. And if these aren't adequately funded, you wonder, how well they'll be enforced. Ashley, I know you've been following a lot of these states and some of the other kind of riders and amendments and the way in which these registries have been expanded. Do you have anything to add to the kind of variety of bills we're seeing around the nation?
Yes, thank you, Tom. And good morning or good afternoon, depending on where you are in the country. Yeah, so I'll just speak briefly to sort of the experience across the Southeast that we've seen with these bills. And I think too, just to kind of tag before I get into that, tag on to something that Megan just said. I think what's important if these bills are passed in your state or are moving is to make sure that we're not diverting financial resources and time and enforcement from other proven best practices on tobacco control policies. Many of the registries are coming, as Megan alluded to, with fees to fund it for the development of the registry itself, maybe even just to put it on the website. But does that really mean employing a staff person who's going to be visiting the individual convenience stores to ensure that these products are removed from the marketplace? And I think, Alabama is one that has had a registry for the last couple of years. And we've had a website, Tom, that you alluded to, that has about 1,600 products on it. But I think as a state, we don't have the financial resources that are lending individuals and staff to actually go out and remove those products from the marketplace. And so I think some of the larger implications of these bills related to any type of public health benefit, we haven't necessarily started to see that. I think this year we also have seen various iterations of this bill, even with some changes. So we have some bills that are moving that have really tried to create exemptions and become vehicles for other types of threats related to tobacco prevention and control issues, such as preemption, but also carve-outs for open system or refillable e-cigarettes, really creating a different dichotomy of products between, states preventing the sale of disposables or single-use products, but allowing for the sale through the registry, for refillable products. We also have seen some states like Alabama and others that have had these registries, or even those that are moving through the process, are now extending it to include non-tobacco nicotine products or synthetic nicotine, given that Congress has given FDA the authority over and instituting a PMTA process related to synthetic nicotine.
Gotcha, thank you. So sounds like a lot of variety across the nation in terms of what's being included or omitted. But as we do know, these are popping up all over the place. And so I'm kind of curious, Claudia, maybe you could weigh in on this. Where are these coming from? Do we have any idea if there's a coordinated effort, or if this is just something's in the water and legislation has been passed around the country randomly?
Yeah, no, great question. Again, good morning or good afternoon for all the participants. Looking at the participant numbers, and there's a healthy number of individuals that are interested in this issue. So definitely appreciate your time listening and learning more about these registry bills. So, one of the first times we saw this e-cigarette product registry bill was around 2020. I believe it was in Alabama was one of the very first states. And so at that time, we were still learning about not only what these bills were, but we were trying to learn who was driving this. It certainly was not coming from the public health, advocates, for all of us. It was not being pushed by us. We, as public health advocates, we know what works. We know what are the proven tobacco control policies that work. And so as these were popping up, we were trying to learn, again, what the actual impact was and is And so we have learned over the last, I guess now 4 years now, that these bills are really coming from the tobacco industry. They are the ones who are, meeting with legislators. There were a handful of these bills back in 2020 and 2021. This year, I think we're close to almost 30 states that we're seeing have this type of legislation. What we're finding is that this is really sort of kind of a market share, right? Type of bill. It's really, what type of products are being sold out there. And so while we look at this from a public health perspective and the public health impact, it's very safe to say that these bills are not proven to have any type of public health impact. So, that is definitely safe to say. We can also say that, public health groups are not supporting these type of bills. Again, it does not have any type of scientific evidence that we would need to be able to support, provide kind of that support. What we are also finding is that over the last 4 years, these bills are evolving. And so as Ashley was just mentioning right now, we are seeing now new type of language from the original ones that we saw in 2020. And so, we're still learning more about this. One thing before we sort of jump into the next question is that, at the very beginning, particularly in states that don't have a statewide tobacco retail license, we want to be clear that this is not in lieu of, and it's not a replacement of. Definitely there's we have seen in the field a little bit of confusion among decision makers. And so while, these are a list, a directory, which in our opinion already exists through the FDA, it certainly should not be taken as a substitute for a comprehensive tobacco retail license.
Yeah, thanks for that. We'll certainly return to that when we talk about some of the trade-offs that you might see with these laws. And just to maybe as a quick follow-up, if you could explain the logic for folks who haven't thought through this as to what makes it a market share bill. Why, if folks like, as I'm seeing in the chat, Altria and RJ Reynolds are proposing these bills, what do they hope to gain from having them enacted into law?
Yeah, great question. So I think we can all agree that, less products on the market can certainly then result in, potentially, some usage. However, we feel like we have some very good proven tobacco control policies that can get to that, such as funding right into tobacco control programs, or looking at existing laws looking at a state's existing laws, or even complementing what the FDA is doing now. And so when we're kind of going back and looking at sort of how the language is being developed and sort of where that market share is coming from, the intent and the impact of this type of legislation is really to push particularly products. Well, now we're seeing, right, with new language coming in and touching on maybe some synthetic nicotine and other products, but sort of the original concept was to try to push products, particularly disposable e-cigarettes, off the market. And so when we're at, state capitals or we're sort of watching who's supporting this and who's not supporting these type of legislation, it really comes down to, a segment of individual vape shop, vape industry associations or owners that are coming opposing this, because they know that that would be an impact to the products that they're able to sell within their businesses. And on the other side, you're seeing, particularly, some of the larger tobacco industry, whether it's themselves or other trade groups, such as grocers associations or some of the retailers, which we know there's a direct relationship between many of the sort of the tobacco industry and many of the retailers out there. And so even, sort of take us out of the picture itself, when you are seeing, tobacco lobbyists talking to members or sitting right next to them in hearings, or, you're just looking at who's on record supporting and opposing this, forget in terms of the details around the language itself, it's very visible that this is really about the products that are being sold on the market. So we feel there's already mechanisms that exist through the FDA that can, build stronger enforcements. But to answer your question directly, again, taking out the language itself and what it's going after, it's just sort of what we're seeing in the field, who's supporting and opposing these bills, and sort of the actual visibility of the groups.
Megan, I see you taking yourself. Do you want to chime in there, or?
Yeah, I just wanted to add too, and that's very diplomatic. In a number of my states, though, it's quite transparent. The legislators, the sponsor, who generally can be a tobacco or a public health ally, is targeted, and they say Altria lobbyists brought this to our attention and they requested that we introduce it. And I see in the chat you're finding that in a number of your states there's no the confusion. They're not hiding the ball. And I also wanted to comment to the idea that yes, there is a marketing strategy, one in which we're seeing prior to, now we're getting the heads up. They'll find a typical public health advocate or someone who has been somewhat vocal in the tobacco control arena, and then they'll place an op-ed. And your keys are usually criticism of FDA enforcement and a targeting of flavored products. But even if that wasn't the case, well, what usually happens is that precedes introduction of the legislation. And when you inquire back to the person who wrote the op-ed, they say, oh, yes, this group called Smarter Regulation, who has ties to the tobacco industry, asked me to place this. And then you see the registry. But if that's not enough, Colorado's legislation, for example, just introduced last week, the exception that's provided for products that have a PMTA in process would only cover tobacco-derived nicotine and would not extend to products using synthetic nicotine. It's another point that suggests and indicates that it's being pushed by the big E6 players, Altria, Joe Reynolds, because those PMTAs were due before September 20th, 2020, and that's what that registry would allow. Whereas synthetic nicotine e-cigarettes were on the market after 2016, and the deadline for them was 2022. So anyone with synthetic nicotine products would not be allowed on this registry, and that would preclude anyone who's not in the big three legacy manufacturers. So I just wanted to make it clear that in any case, the industry is being fairly open about their support and pursuit of these pieces of legislation.
Yeah, that's a fascinating wrinkle to that Colorado law. Thanks for bringing that to our attention. And just to kind of connect the dots here a little bit, because I'm seeing another question in the comments. I think what we're hearing here and what we're seeing, and if you think back to the discussion at the beginning about the FDA PMTA process, there are companies like Juul and Altria who have gone through the FDA's PMTA process. They have pending applications. They have denials that have been stayed. And thus, according to these registries, they have products that would qualify for the registries and hence could be sold in the state. There are other companies, typically foreign manufacturers, who never submitted applications to the FDA. They have not gone through the PMTA process, and thus they would not qualify for these registries. And these are the companies that are typically producing things like the disposable vapes. And so it's what I think I'm hearing from the panelists is that this is a market share bill in the sense that the only products that could be sold in these e-registry states would be those products that have gone through the FDA PMTA process, products that are coming from these larger manufacturers, keeping out competitors. And so that actually transitions into the next question. Of the states that have actually implemented them, are we seeing an effect? Do we have any evidence to say that this is reducing the number of products on the shelves or improving public health at all? And Megan, not to pick on you, I know you put some work together on Oklahoma's e-registry. Do you have anything that you can share about that?
So we truly have a sample size of one, given that Alabama is the only registry that's been operational for over a year. I had a colleague send me a really interesting question last night about do we have any measurable health incomes pre-registry implementation, post-registry implementation. So Louisiana and Oklahoma have not been operational for over a year yet. Alabama is the only one that we can look to. And unfortunately, we have Youth Risk Behavioral Data Survey information from 2021, but Alabama has opted out of the CDC's Youth Risk Behavioral Survey prior to 2022. So we've had a year now worth of this implementation for the Alabama registry. So we don't have true a true variable at the moment from which to assess any pre or post public health impact. One measurable, I even attempted to look at sign-out rates, and many of those sign-out rates aren't published in the public sign-out report, so that will have to be a records request. And sign-out has to do with the number of violations for sales to youth under 21, sorry. And again, that data we could look at pre-implementation of the registry and post-implementation. I did go through the data for Alabama pre-implementation for T21 violations involving e-cigarette sales to youth through FDA inspections. Unfortunately, those include products that are not simply e-cigs. And so those T21 violations, did retail violation rates go down, meaning were they more compliant with e-cigarette protections regarding youth access laws prior to or post implementation of the registry? And those numbers are the exact same prior to 2022 and 2023 to the existing month, which we'd need another couple, because regardless, the registry was implemented in May of 2022. So we would need data from prior to that, post that, and we don't have enough of that public health variable, right? That outcome variable. So we'd love to look at demonstrable public health impacts. Unfortunately, all we have to assess is the lack of resources for enforcement and the cost of these registries, and in a way, removing resources that might go to evidence-based public health protections with respect to tobacco sales or any tobacco control.
Yes, hi. Tom, can I just share or wait?
No, go ahead. Sorry, I was going to ask Megan about the graphics she provided, but please do jump in.
Yeah, one of the things I wanted to speak about, I know the question was about state. At San Francisco, it's a very local, we only have 596 permitted businesses. We have a field team of 1.5 persons. And then what we're finding is every time that we go out in the field, we are finding the e-cigarettes on the shelves. We are finding flavors on the shelves. The other thing is that we have expanded our field team to include our food inspectors, because a lot, we looked at our data and we saw that 85% of our businesses had a food permit. So that added another 25 teams of people looking for these products on the shelves. In our inspection reports, when it came back, they said no violation. It wasn't until I was hearing from our community members, people were selling these cigarettes, that we literally had to switch our practice and sending out secret shopper. So we had to find a secret shopper, set up a contract with a secret shopper, and as we're sending out the secret shopper, we are not only finding that e-cigarettes are being sold by our permitted businesses, they're also being sold by businesses that don't have a permit. Right now, I have 12 enforcement cases on my desk. Before the law, it would be maybe 2-4 enforcement cases on my desk. So I'm seeing an increase. So even though, as I shared with everyone, we're only looking at the FDA authorized products. The FDA has come up with a simple list. That is the list that we use. That list, that information, even if it's reaching our permitted facilities, we're still finding these products. So it is a very challenging environment right now, and that environment has changed quite a bit.
Yeah, thank you for that. And so again, I think what I'm hearing is that it's great to have it limited to just a list of 23. It makes it a lot easier, but there's still problems. And so the idea that you could have a registry with 1,600 or 10,000 products and somehow, get rid of illegal vapes is maybe overly optimistic, we'll charitably say. I did see a question in the chat about Altria verbiage about the experience in Louisiana. And I'm not sure, Claudia or Ashley, if one of you is able to respond to that.
Yeah, I'll happy to take it. But before I do want to just sort of tag on to something that Megan and we just talked about related to San Francisco, is just really that, the implementation of the E-Registry bill, for example, in Alabama, is only as good as the funding and actual enforcement that we have in the state. So Alabama as a state, prior to even the E-Registry, we were not adequately funding tobacco prevention, control, enforcement, and compliance. And I think in the chat, a colleague from the Heart Association referenced that we've only really brought in about $24,000 with the fees associated with the registry. And that doesn't even fund a staff person really to go out into the state, to the convenience stores to truly enforce. So I think really, in absence of a comprehensive tobacco retail licensing program, which Alabama doesn't have, and we're instituting additional regulations for enforcement and compliance, then we're not going to truly see any type of public health benefit from this types of law, and just more tobacco control statute that we're not enforcing. And so to your question around Louisiana, obviously Louisiana did this past legislative session, passed a registry bill that was tagged along with a low e-cigarette tax. The state began to implement the registry, but was quickly filed a lawsuit that has been off again and off again, on again and off again, but currently is under a temporary injunction. The Alcohol Tobacco Control Division, and so they're unable to enforce that. So it's currently under litigation, and I think we really just don't have the data right now to say whether what the industry is putting out there is true or not.
Yeah, and I think that's something worth emphasizing. It's hard to verify the facts in the best of circumstances, but especially if it's coming in a kind of PR sort of form from an industry member. But we've got 24 laws across the nation, and it sounds like they're not being based upon a robust evidence-based public health consensus that these laws work. That's kind of sounds as much like a hunch as anything else. And I like your point too, that a law like this can only be as good as the enforcement of it. So, nuts and bolts, how much money is being invested into enforcing it, cleaning up the registry, making sure you've got people who know what should be on it and is not on it, and that they can find that in the stores. Megan, I know you had supplied a graphic for Oklahoma's registry. I don't know if you want to take a second to kind of show us what we're talking about here when we're mentioning how complex these registries can get.
Yeah, so this is a sample of the registry as it was published prior to what's the legislation that's going on now to help clean up the bill. So this is just one section, and it's to give you a visual of what it really looks like, what this ABLE commission that was first charged with it will eventually transfer to the AG's office, because it was an overwhelming amount of paperwork. And you can see they're not consistent reports of products. In addition, if you're looking at enforcement, the 10,000 products are listed. And so you would have an enforcement officer go out and check for these products, including the canisters, depending upon volumes, types. Very difficult for anyone to do. And so I think the ABLE Commission is right on the ball in trying to fix what is already in existence, because you can see not even all the manufacturer report variable categorizations in terms of what does pending mean? What does yes mean? And in a lot of these registries, there is no true authorization that can be done at the state level to ensure that there is a final marketing order or an MD MDO because you can go to the FDA's website and see that not all MDOs are published. And a lot of that trade material is private as well, under proprietary concerns. I also wanted to just mention, and I'm losing my train of thought, is that in some cases, what happens too is they have to continuously update these on an annual or a monthly basis. And so you can see if a volume or a cartridge base has changed or a type of product has changed. Don't want to get too far in the weeds. How do you update that list? How do you update then in reality? What does that logistically look like for someone like Janine to go out and say, okay, this one is on it. This is no longer as of last month. So very, very burdensome and complicated. So difficult not only with the registries that are in place, but how this will be organized for future registries or legislation pending. I thought the visual might help to see the reality of what one of those registries actually looks like.
Certainly. Yeah. Thank you for sharing that. And that kind of neatly transitions us to the third question. One thing I want to focus on when we're asking about the public health impacts of these bills, to the extent we know about them, what are the potential trade-offs? And is that something that you all are seeing in the states that are considering these? Are these bills coming at the expense of other approaches to commercial tobacco control? Do they implicate preemption issues? Or what are some of the other strategic policy considerations that we should be thinking about when we think about these bills in public health?
So I'm happy to take that, Tom. Yeah, absolutely. So, like I had mentioned earlier, the bills that were, the bill language that was first introduced in 2020 really has evolved over the last 4 years. And so when we were talking about here, so what are the components, right? And so you're talking about, what are the requirements to get on this list? As we've been talking about there, the initial ones didn't really build a lot of enforcement in there. And so that's sort of that discussion that's happening now. I think what's surprising is that decision makers are having sort of this whole conversations around how to enforce and put resources, even significant resources in some instances, on enforcing this type of product registry bill, while dismissing looking at their existing laws and looking at how they can improve, and then maybe put those funds in terms of some of the existing programs that already exist. I think where advocates are finding themselves now, Tom, is that, the language itself is not in its simplicity as it was even in 2020. And that was while we were trying to understand really, what is going on in the implications of such language. I think somebody had asked, and maybe in the Q&A or the chat, like, are we seeing these type of language in states that have preemption, or, originally I thought, well, are they really, we're seeing this language around maybe states that don't have a tobacco retail license. To be honest, I haven't been able to find out, like, sort of what is that mechanism around what states we're seeing this language. Is sort of, we're just seeing them all across the country now. But as I mentioned, these are opportunities. And they're using these opportunities to change existing definitions that a state may have. They're changing languages such as the one in Alabama, where they're adding in, sort of maybe some new products that can be sold on the market in the future, that can then, be put on this list that can then be sold in the state. I think there's still this sort of question mark around, although Ashley can talk more about that amendment in Florida that we just saw this week, but nonetheless, it's sort of like, because it's not in its simplicity, what type of implications do these bills have towards existing federal laws, or within the FDA and them enforcing their laws? And so, can these e-cigarette product registry bills sort of survive or live in this environment, and sort of say, well, at the end of the day, we're going to remove these products. I think what we're finding now in the languages is that they're doing more than just that. They're trying to allow more products to be sold in the state, or at least opening the door for that. It's sort of then answering this question mark around, like, implications around existing laws within the state, or with state versus federal. So there's a lot of question marks. And I think what I'm finding that's more, surprising is that decision makers are spending so much time trying to make this work, while that time can be better served, as I said, if they really truly want to make a public health impact, and that really is the goal, then they should, been looking at maybe strengthening their tobacco retail license they have, and they're putting more money into their programs. So, again, I'm going to end with this, can it work in a perfect world? I think it's too early to say in that. What I can say is what we're seeing right now, they're getting worse. And as I said, they're opening the door for maybe preemption. They're opening the door for youth penalties. They're opening the door for changing definitions. And I think that right there is sort of where we as advocates need to be very cautious, very alert, and really looking at these bills through sort of that lens. What else are they trying to do?
That's really well said. Thank you. Ash, I don't know if you want to share about the Florida bill, or we can kind of pivot to the last question, which is maybe dovetails with that. And I think we're building towards this consensus anyways, but whether in your estimation, public health advocates should oppose or support these bills, or how should they strategically handle them in their states?
Yeah, so I'll just take a moment to address sort of what we're seeing in Florida. So Florida is in the process of trying to push for a registry bill. And, the bill has gone through, and Florida has to go through 3 committees on either side, and really has moved through the process without really any major hiccups. But I think certainly what we've seen is the sort of market share debate among the industry in that bill. And really sort of what happened earlier this week was that an amendment was filed, a strike all amendment, that is, I think, attempting to be some sort of negotiation among the industry, and really trying to sort of counter the opposition from the Florida Smoke-Free Association, who is saying that this registry is going to put them out of business. Now, big picture, let's talk about the fact that these products are already having to have been applied through the PMTA process. Some of them may or may not have received a marketing granting order. Many have received marketing denial orders, and really shouldn't be on the market in the first place because of federal law. But the amendment that we saw is really sort of a different version of a registry. It is really sort of giving some discretion to the Attorney General to create a registry for e-cigarettes that are, quote, attractive to minors. In the legislation, it does give some parameters around what that would be considered, but it clearly creates an exemption for open systems, for refillables to continue to be on the market, which is really going to create, if it becomes law, a division between what's state law and being sold in the state versus what federal law is, and certainly can open the state for legal action. And just creating that dichotomy of what state law is versus what federal law is, and what products are more confusion around what products should be available in the marketplace.
Yeah, thank you for that. And, so I think that we've kind of covered the 4 topics really well over this conversation. And there's so much to be said here. We could have, multiple hours, if not multiple days worth of discussions on these bills, but I do want to leave some time for Q&A. And so I know, Marissa, you've been tracking questions as we've been going along, and I'll kind of pivot over to you now, and you can raise those questions to the panelists, and we'll answer them to the best of their ability.
Oh, great. Thanks, Tom. So yeah, we've been getting a steady flow of questions both in the chat and directly to the panelists as well. And I think, Ashley, you just touched upon this in your remarks, but I want to kind of flesh it out a little bit more, and really about the preemption issue or conflict of laws issue. And that first, we did have a question directly just asking, are most of the registry bills in states preempt local control? And I think that question is saying, can local jurisdictions have their own registries? Can someone on the panel answer that question, and whether or not the language in those bills have that type of preemptive language over local units of government?
Yeah, happy to answer that question. I mean, I have not to date seen a bill that would say that localities are preempted from creating their own directories. But what I could say around preemption is that certainly this type of bills could serve as vehicles for states to add further preemption, in other type of policies. So from that aspect, definitely be on the lookout and look into that language. But no, I don't know, Ashley, Megan, you've reviewed several of these bills as well, but today I have not seen anything that would say or preamp localities for sort of setting up their own directories.
Yeah, Claudia, I would agree with you. I think the major concern around preemption is just that these bills being filed become vehicles for other bad tobacco control policies like preemption, like changes in definitions, of tobacco control statute, just other writers for other bad policies that the industry wants to push in individual states.
I second or third, I guess, in that if not explicit, then implied, because you could theoretically have a situation in which a state has a registry and a local ordinance has adopted some sort of, and I know in Ohio, one of the, not even dealing with flavor restrictions, but rather disposable restrictions. And then if those products are allowed on the state registry, who, even with no state preemption at the moment, right, which registry dominates? And so I think this is also setting up a fight among federalism at its best, right? The federal government says the FDA should regulate these products, and yet these states now are taking authority to say, hey, we want to decide too. So if not explicit, definitely implied preemption with these bills.
Yeah, and I think relatedly on the federal preemption question, these state bills clearly seek to regulate what products can or can't be sold on shelves within their jurisdictions. And I think, you can very clearly and succinctly argue that, all these state registry bills wade into the FDA's regulatory authority for authorizing these products for sale. And so I'm just wondering if anyone has any comments in that regard, to the extent that once, assuming they pass and these laws are implemented, to what extent do you anticipate legal challenges being brought? Maybe circling back to the market share issue in terms of, the companies that feel like they're being pushed out might seek to challenge on this basis. Any thoughts or comments on that?
Well, I'll just say we've already sort of seen that, right?
Okay. Hard to say, but yes, we are seeing it in one state at least.
And
Yeah.
given what we saw, I'm sorry, go ahead, Ashley.
No, I was just going to echo what Claudia said, is that we're already starting to see that with litigation in Louisiana and implementation, being enjoined. And so the state's not able to implement that and going through the legal process. So
And Megan, were you going to chime in or no? Okay.
I was just going to say that even without the idea of in Arizona, right, it was almost like litigation in a committee hearing between the independent vape industry and the legacy manufacturers lobbyists. There was a huge debate. I can imagine if that was adopted, it would definitely go straight to the courts. So if not in reality, in theory as well.
Right. I think in our 2 minutes or so left, I would love to hear from as many panelists as we can, as time allows, for just kind of the key messages for made by public health advocates, other people who are working in public health. Like, what are the strongest messages or talking points that we should take with us as we move forward and are facing these pending pieces of legislation?
I guess I'll start. Just from an enforcement perspective. So when we passed our flavor law, we actually, did some, review some data. And after the policy was passed, we actually saw a decrease in our youth accessing flavored tobacco products. We saw a decrease in our youth saying that they use vape for the first time. And I think that when we passed the e-cigarette law that said that you can only sell products that have the FDA pre-market approval, pre-market authorization, that was when it has been like more challenging. And that was because there's just been a lot of confusion. I think that one of the biggest messages I would put, that there must be staff and funding to educate retailers, to even educate the people who are going out in the field supporting these inspections. One of the most positive things out of all of our challenges that in the Bay Area, we have been communicating across departments. So I have meetings with code enforcement, law enforcement, and even some of the city attorneys and district attorneys to talk about the challenge that we face and the different ways that we are enforcing and how we can be more standardized. So my message would be is that with these laws, there must be staff and funds to actually enforce.
Thank you, Janine. Megan, Claudia, or Ashley, do you want to sign off on some parting wisdom on key messages that public health advocates can use when facing this legislation?
I'm happy to take it. I mean, I think we've sort of has said this and reiterated it over the last, 30, 40 minutes that we've had this discussion, is that what we know is that these bills are not, it's not one of the proven tobacco control policies that we know. And so for those advocates, I think, one, it's important to sort of definitely take a look at this, be cautious about what, especially the new language that's being added into these bills and how that can have impact in other laws. But go to your decision makers, talk to them about those tobacco control policies that are proven, that we know that do work, that do have the data. Let them know that this is not one of them. In fact, what we're seeing in the field, as we reiterated, is sort of more the tobacco industry and some of those partner groups, versus, the sort of the vape associations and groups. And I think that in itself is telling. So I know we don't have time here because there's a lot of other talking points, but if anybody's going to take anything out of it is at the very least, no, this is not a proven tobacco control policy. Decision makers need to know that, and they need to know who is behind these bills. And it is not the public health community.
Claudia, I'll bounce it back to Tom, I think, to wrap up, and just personally thank you to everybody today for lending your expertise on this topic.
Yes, thank you very much. So I want to thank you all for being here today. I really appreciate the attendees and for your very thoughtful questions and your engagement. And I want to do a special thanks to our panelists for donating their time and their knowledge and expertise. I think we all learned a lot and benefited from their discussion. And so thank you again to them. As Stephanie mentioned, we will circulate a survey about this webinar after the fact. I have contact information for PHLC up on the screen right here. So if you have questions we haven't addressed, and especially if you have state-specific questions about a bill that's being proposed in your state, please do let us know. If Marissa or I can't answer it, we have some experts that you see here up on the screen who we will reach out to and try to help you. So thanks again, everybody, and we will continue this conversation, continue tracking this, continue providing information on it to the best of our ability. Thanks again.